Welcome to the appendix, where we read the primary sources of the past so that the present can be better understood. Today's primary source, the Quock Walker Case, Massachusetts, 1783. The status of slavery in Massachusetts was, throughout the Revolutionary period, a matter of uncertainty. As early as 1770, 2 years before Lord Mansfield's decision in the famous Somerset case, in the case of James v. Lechmere, the Superior Court of Massachusetts ruled that the plaintiff, a negro, was entitled to his freedom under the laws of the province and the terms of the royal charter. In the course of his decision in the case of Winchendon v. Hatfield, Chief Justice Parsons said, quote, "Several negroes born in this country of imported slaves demanded that their freedom of their masters by suit at law, and obtained it by a judgment of court. The defense of the master was faintly made, for such was the temper of the times, that a restless, discontented slave was worth little, and when his freedom was obtained in a course of legal proceedings, the master was not holden for his future support if he became poor. But in the first action involving the right of the master, which came before the Supreme Judicial Court after the establishment of the Constitution, the judges declared that by virtue of the first article of the Declaration of Rights, slavery in this state was no more." Unquote. This was the case of Quock Walker vs. Nathaniel Jennison, 1783. Jennison, indicted for assault on Walker, justified his assault on the grounds that Walker was his slave. The court, however, speaking through Chief Justice Cushing, ruled that the first article of the Declaration of Rights had abolished slavery in Massachusetts. The case was not reported, but in 1874, Chief Justice Horace Gray read from the original notebook of Chief Justice Cushing the following extract from his decision. Cushing, Chief Justice, as to the doctrine of slavery and the right of Christians to hold Africans in perpetual servitude, and sell and treat them as we do our horses and cattle, that, it is true, has been heretofore countenanced by the province laws formerly, but nowhere is it expressly enacted or established. It has been a usage for which took its origin from the practice of some of the European nations, and the regulations of British government respecting the then colonies, for the benefit of trade and wealth. But whatever sentiments have formerly prevailed in this particular, or slid in upon us by the example of others, a different idea has taken place with the people of America, more favorable to the natural rights of mankind, and to that natural innate desire of liberty, which with heaven, without regard to color, complexion, or shape of noses, features, has inspired all of the human race, and upon this ground our constitution of government, by which the people of this commonwealth have solemnly bound themselves, set out with declaring that all men are born free and equal, and that every subject is entitled to liberty, and to have it guarded by the laws as well as life and property, and in short is totally repugnant to the idea of being born slaves. This being the case, I think the idea of slavery is inconsistent with our own conduct and constitution, and there can be no such thing as perpetual servitude of a rational creature unless his liberty is forfeit by some criminal conduct or given up by personal consent or contract. Verdict, guilty. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.